Ed is in some serious trouble.
This is me advising you that failure to provide that DNA sample is a felony.
Ed is pulled over by the police in Alaska, and they got an alert.
You have a locate in the computer system that says you're required to provide a DNA locate.
What? Is Ed really going to be charged with a felony? A felony for refusing to provide his DNA to this officer on the side of the road? Let's dig into what's going on here, and Officer Johnson gives us our first clue.
Basically, the state changed a law earlier this year where they're retroactively collecting DNA on previous convictions.
Alaska's DNA for criminals law was amended in 2007, which requires the government to collect a DNA sample for anyone who was even arrested for a crime against another person. Which, first of all, the United States Constitution prohibits ex post facto laws, which means the government can't criminalize things today that you did back in the past. That's a good thing, or else we all might be in jail for things we did in high school. But you may think this is no problem because the government's not coming for your DNA. They're probably just looking for people that committed things like felonies, murders, and sex offenses, right? Nope. Alaskan law says that DNA must be collected for offenses including felonies and any crime against a person. Well, what does that mean? A crime against a person. Let's say you're at a sports bar watching a sportsing match and you get into a heated verbal argument with some of the fans from the opposing sportsing team. A shoving match ensues, and now you're arrested and accused of battering the other person. A simple, unlawful, and offensive touching of the other person. That push just made it where you have to submit your DNA to the Alaskan authorities because that's a crime against a person. Alaska, the country's last frontier, the state that's home to people like Tony Beats and the Kilcher family. So was Ed ever arrested?
I was not convicted of any crimes.
You were convicted of a mixed 4 in 2007.
Absolutely not convicted. I had a SIS.
A SIS is a suspended imposition of sentence, which is fancy lawyer talk for saying he was not convicted of the charge at the end of the case. So Ed was arrested, but he was not convicted of this offense that Officer Johnson is talking about. But wait, does this mean Alaskan law is requiring innocent people to submit their DNA samples to the state for testing and processing? Yes, and I think that is preposterous. Remember that in our entire country, including Alaska, we have a presumption of innocence, which means you're innocent until proven guilty. Anyone can be accused of an offense, and just because you're accused does not mean you'll be ultimately convicted. If we're going to collect DNA samples for serious and violent offenses, it should only be done if the person is actually convicted of the serious or violent offense. Okay, so is Ed required to give his DNA to Officer Johnson? Yes. There's an entire report from the Alaskan government about people who lawfully owe their DNA to the state. And there's even a website from the Alaskan government where you can type in your information and see if you, in fact, owe your DNA to the authorities. Without knowing more about Ed's case, it's hard to know if he in particular is on the list, but it sounds like he likely is based on an arrest many years ago. 21,577 people, in fact, owe their DNA to the state of Alaska. 1,555 of those people are dead. I guess the Alaskan authorities can try to harvest their DNA from their mail-in ballots. Of the remaining people, 32% of them were arrested or charged with a crime, but were found not guilty of any offense. But the state of Alaska is still hunting them down to collect their lawfully owed DNA. Quick side note here, Alaska law also has a provision to destroy DNA for people who were arrested or charged but were ultimately acquitted or found not guilty. But the state still wants to collect these DNA samples so they can run these DNA samples through their databases to look for cold hits because they never got to run them in the first place. Then those folks should be able to petition the court to have their DNA samples destroyed. But if you believe any government data that they collect about you is actually completely destroyed, I've got some oceanfront property in Arizona to sell you. You can see the sea right from the front porch. Only 44% of the wanted DNA profiles in Alaska were actually convicted of a qualifying offense under their DNA collection laws. And all these are murderers or sex offenders, right? No. 55% of them were only convicted of a misdemeanor crime against another person. That's likely things like simple assault and battery, or maybe something as heinous as pickpocketing. So is Ed really about to get arrested and charged with a felony for not giving Officer Johnson his DNA? No. Alaska law does make it a felony to refuse to provide your DNA sample under certain circumstances. But in order for the refusal to be a felony, you have to have actually been convicted of one of these qualifying offenses. Now, the government might go to court and get a court order trying to compel someone to give their DNA, and then you could have other problems for disobeying that specific court order. What does Ed do in this case?
No, I'm not submitting to anything.
I'm so proud of you, Ed. To learn more about your rights in a traffic stop, check out my next video. I'll see you over there. And remember, don't talk to the police.